Welcome to the Workplace Minute, powered by H3 HR Advisors, and sponsored by Paychex, and also sponsored by WorkHuman. My name is Steve Boese. How workplaces are preparing for I-9 audits and ICE raids. With all the news surrounding the new presidential administration's crackdown on undocumented individuals and workers, it is not surprising at all that HR leaders and business owners across the country are increasingly aware and concerned about how to navigate potential investigations and enforcement actions from the federal government. To help address these concerns and provide essential information to the HR community, our friends at Paychex, in collaboration with the law firm Fisher Phillips, this week presented an important and incredibly interesting webinar on the topic titled I-9 Audits and ICE Raids: What Employers Need to Know to Stay Protected. The attorneys from Fisher Phillips set the stage for the conversation by noting that the new administration is commencing with plans for large-scale deportations, aiming to remove millions of undocumented individuals from the country. And they also plan to build expansive detention facilities and are deputizing local law enforcement to assist in federal immigration enforcement efforts. And Immigration and Customs Enforcement, or ICE, has begun conducting raids and arrests on a wide scale. Since we all know that many of the undocumented individuals and those who may be identified as potentially undocumented are presently employed in the U.S., it makes workplaces and job sites prime targets for ICE and Customs and Border Patrol investigations and enforcement actions. Paychex and Fisher Phillips webinar broke down the types of possible federal government interventions that could impact employers and offered recommendations for employers in advance of, during, and after any enforcement actions are undertaken by ICE or Border Patrol. There are three main reasons why ICE would show up at a work site. One, to start an I-9 audit with a document called a Notice of Inspection. Two, to conduct a workplace raid. Or three, to attempt to detain a specific person. Fisher Phillips noted that for reasons 2 and 3, to conduct a raid or to detain a specific person, a judicial warrant signed by a federal judge must be presented. For the remainder of this Workplace Minute, we will focus on worksite raids and leave the topic of I-9 audits for another conversation, as it can get very detailed and precise. The presenters then offered several recommendations and best practices for employers if and when they are investigated by ICE agents at the worksite. Organizations should first identify an internal point of contact for all correspondence with federal agencies and make sure all employees know how to contact this person. Next, they should provide employees clear instructions on workplace rights and responsibilities in the case of a raid. And third, they should restrict unauthorized access to non-public areas of the business unless legally required. Additional recommendations were also shared regarding the presentation and examination of any warrants presented by ICE agents. Employers should always request to see a warrant prior to granting access to employees, documents, and non-public areas of the worksite. If a warrant is presented, they should examine it carefully and determine if it is a judicial warrant signed by a federal judge or an administrative warrant that's signed by an ICE officer. Once a warrant is presented and confirmed, the attorneys advise employers to cooperate within the limits of the warrant, to not interfere with officer search and seizure within the scope of the warrant, and finally to record the details of the search, including all items taken and persons spoken to or detained. Finally, the attorneys had some recommendations following any worksite actions from federal investigators. After any raid, the organization should conduct a debriefing with key personnel to document the event, and then they should consult their own immigration attorney to assess the situation and respond appropriately to any follow-up actions. And they also should provide necessary support to any affected employees. With increasing focus on immigration enforcement and worksite raids by federal agencies likely to become more frequent in 2025, employers must be prepared to protect their businesses, their employees, and their proprietary information while also following the applicable laws and cooperating with any legal investigations. Thanks to Paychex and Fisher Phillips for making this information available. It is a great educational service to the HR and business community. And please note that this recap of the recommendations is provided for informational purposes only and should not be considered as legal advice. Organizations should also consult with their own attorneys in these matters. That's it for the show today. We will continue to follow this and all the important topics and trends in the world of work here on the HR Happy Hour Media Network. This has been Steve Boese for the Workplace Minute, powered by H3 HR Advisors.